law firm. Currently, its branches in Mumbai, Delhi, and Goa. As a co-member of the corporate or commercial team, Rohini has negotiated and closed many complicated transactions on the aforementioned with her team. She, along with the team, deals with matters such as corporate restructuring, mergers and acquisitions, joint ventures, private equity, and several corporate commercial transactions, including licensing and transfer of technology across several sectors. Rohini also advises clients on strategies for structuring transactions, conducting due diligence exercises, and drafting and negotiation of transaction documents. Rohini's forte is in restructuring and cross-border transactions involving multiple jurisdictions. We have Nasneen, the second speaker, yeah, Ikapuria. Nasneen is also a partner with A&B Legal since 2014 and heads the private equity, mergers and acquisitions, and general corporate practice of the firm. She has more than 10 years of experience in the legal profession and specializes in matters relating to private equity, venture capital investments, acquisitions, joint ventures, and cross-border transactions. She has considerable knowledge and experience in drafting, vetting, negotiating, and advising on a wide range of transaction documents and issues across diverse sectors such as e-commerce, pharma and healthcare, logistics, infrastructure, information technology, media, and communication. Nasneen has authored several interesting articles on topics ranging from technology and social media to arbitration and dispute resolution, which has published in India, as well as leading international publishing house. She's also a member of the Law Review Committee of the Indian Merchants Chamber and the International Council of Jurists. So welcome on board, Rohini and Nasneen. Over to you guys.
Thank you, Amit, and thank you, Nirmal. Well, like Amit and Nirmal rightly said, that today we will be briefly discussing on the kind of entities that a startup founder can look at. Once you've decided to be an entrepreneur and put on your entrepreneur hat, which is the entity that you can choose to do business through is something that that's one of the main topics that I'm going to be dealing with today. And I'll be happy to take questions post session. Before I kickstart on the basic structures which are available to any promoter founder to do business, uh, I'd like to tell you that we are a full service law firm which has offices principally in Mumbai and other branch offices in Delhi, Goa, Cochin, and Calcutta. We also have a startup cell through which Nazneen and I, in fact, cater to a lot of startups across sectors. And today, what we intend to do is not just give you a legal perspective on a couple of aspects, but also to probably share our personal experiences as and when we've dealt with startups, so that you so that you are aware that what are the practical challenges involved in this particular space. Now, moving on to the basic structure. So today we have covered four of them, which is the private limited company, which is governed by the Companies Act 2013. Then you have the LLP, the Limited Liability Partnership, which is governed by the LLP Act 2008. Then the sole proprietorship firm and the partnership firm, which is governed by the Indian Partnership Act 1932. So these are the basic differences. Now here I haven't really covered the OPC, one person company, which is more or less like the sole proprietorship, just that it is governed by the Companies Act 2013. And the fact that the liability of the sole proprietor is limited and if it's an OPC. Now, coming to the governing act. Now, there is no act which governs a sole proprietorship. While there is an Indian Partnership Act 1932, which governs the partnership firm. whether, well, you could be registered or you could not be registered. So it could be either. It's not mandatory to get yourself registered as a partnership firm. However, it is advisable to do so. Then you have the limited liability partnership, which is governed by the LLP Act 2008, and a private limited company. Here we haven't really covered the public company because more or less as a startup or an MSME, you generally register yourself as a private limited company. Now, because there are because the last three, partnership firm, LLP, and private limited company, is governed by a statute, there are certain compliances also to be carried out that needs to be kept in mind. Now, and under law, in the eyes of law, sole proprietorship and a partnership firm is not considered separate from the owner. Hence, the owner of the firm or a sole proprietorship is generally exposed to unlimited liability. So that needs to be kept in mind. So what needs to be kept in mind is, what the question that you need to ask is, whether are you okay with an unlimited liability exposure. And when I say separate legal entity, the question is whether the business is considered legally and financially separate from the owner. In case of an LLP and a company, it is considered different. So in case there's any liability, any claims that arise on a LLP or a company, the personal assets of the shareholders or the promoter co-founders is not affected, right? Then coming to liability. Now, because in the eyes of law, a sole proprietorship and a partnership firm is not considered separate from its owner, the liability is unlimited, like I said. And as far as the LLP and private limited company is concerned, it is limited to the contribution of the share capital of the company. Now, in case of a sole proprietorship, the minimum number of members is obviously one, and partnership is two. LLP is two designated partners. Now that has to be two individuals, and at least one of them being a resident in India. That is, they should have stayed in India for not less than 182 days in the preceding year, right? And while it's two designated partners, you could have multiple other partners, but designated partners, you need at least minimum two. Uh, as far as the members are concerned in the company, it has to have two shareholders and two directors at least. Now, two directors, out of that, one at least needs to be resident in India, right? Then maximum number of members, as far as partnership is concerned, it's 100. LLP, it's unlimited, and for a private limited company, the threshold is 200. Now, since the sole proprietorship is not really governed by any statute, there is no formal registration required. While, like I said, a partnership form, it's not mandatory to get yourself registered. But if you do register, then it has to be registered under the Partnership Act. Then the LLP needs to be registered with the MCA under the LLP Act, and so is the case for a private limited company. Now, because there is no statute governing it, and it's only one person in case of a sole proprietorship, and in case of a partnership, it's just the partners. The entity cannot be transferred. While in case of an LLP and the private limited company, the ownership can be transferred the way it is structured. As far as the annual filings, compliances, audit requirements, now, because a sole proprietorship and a partnership firm is not very structured, there are no annual filings to be carried out, and compliances, it's very least as far as the sole proprietorship and partnership is concerned, which means that there is less cost involved. While in case you have to carry out any compliances under the LLP Act and the private limited company, there are certain ROC filings to be made under the respective statute. So that needs to be kept in mind. It's a cost which is involved, which you need to keep in mind before you set up an entity. You need to make up your mind that that needs to be done. But with those kind of compliances and filings, one should also make note of the fact that because these compliances are in place, there's complete transparency. And if I have to talk from an investor's perspective, they would always prefer a company or a LLP to invest in, because there are compliances done. There is complete transparency. Everything is available on the public domain. Okay, and it's compliant, and it's functioning properly. So that these compliances are to ensure that the company is operational in a structured manner, right? Thereafter, the audit requirement, obviously sole proprietorship, there is no audit required per se. For a partnership firm, if the threshold turnover limits are specified, and if in case it goes beyond the threshold, then you need to carry out some audit. For LLP, if it exceeds the turnover of 40 lakhs, or the capital contribution exceeds 25 lakhs, then yes, you need to get an audit done. In case of a company, you need to do it regardless. Uh, the other thing that I would like to point out is that in case you're looking at the OPC, a one-person company which is registered under the Companies Act, what you need to keep in mind is that while you could limit your liability, that's one benefit that you get in case of an OPC, that the founder, the promoter, the owner, whatever you call it, their liability is limited. However, if your revenues go over 2 crore or your paid up capital goes beyond 50 lakhs, then you anyway need to convert your OPC to a company. Also, what happens is you need to identify first whether are you looking at getting in funds tomorrow from a third party. In case you're intending to go bootstrap all along throughout the business, the life of the business, then you could probably consider a sole proprietorship or a partnership. However, if your aim, your objective is to get in investors tomorrow, then it was advisable to go by a LLP or a private limited company route. Now, because there is no transferability possible in case of a sole proprietorship and a partnership, the survivability is also a question. So the sole proprietorship, the existence of it is dependent on the proprietor, and so is the case for a partnership firm. In case of an LLP, the existence of a LLP is not dependent on the partners, and in case of a company also, it's not dependent on the shareholders, because the shares can be transferred, right? In case of annual statutory meetings. Now, in case of a sole proprietorship firm or a partnership or a LLP for that matter, there are no annual statutory meetings required. While in case of a company, like you're aware, the board meetings need to be at least 4, which needs to be conducted. There needs to be one annual general meeting to be conducted. There will have to be matters for which shareholders' approval will be required. For some, it will be special resolution. For some, it will be ordinary resolution, depending on what the matter is. In case if it's about amending your charter documents, or in case you intend to raise further capital for the company, then yes, you have to take a special resolution, which means 75% consent of the shareholders. In case there are simple matters, then an ordinary resolution of 50% majority would do. So it's completely governed by the rules and regulations of the Companies Act and its rules. Now, in case you intend to at some point in time get in investments, foreign investments, then you need to be aware that a sole proprietorship and a partnership is not allowed to get in investments from any foreign investor, while an LLP now is permitted under the FDI policy, and so is a company. Just that you need to fulfill certain norms under the RBI regulations, the FEMA regulations need to be kept in mind. And the last but not the least is the sustainability. Now, like I said, in case you want to keep complete control of the company with no interference from a third party, then yes, you can very well go ahead and do a sole proprietorship. Okay, but you need to bear in mind that if you are considering a company or a LLP, then you have to be mindful of the fact that your control will at some point go away. You will have to give away control. There will be certain decision making powers that the investor would seek from you in case they are putting in money. In case of the LLP and a partnership firm, the growth is certain. So in case you're looking at a growth stage business, then yes, you should consider a company or a LLP. Compliances, like I said earlier, LLP and a partnership, an LLP and a company does require a lot of compliances. It does involve cost, but it is certainly regulated. And in case you're looking at funding tomorrow, then that's the best way to go. That's the best route to take. I think that's on, and obviously personal liability protection. So, in case of a LLP and a company, the members, the shareholders, the directors are very well. Their liability is protected. So, in case you enter into a vendor contract through a sole proprietorship firm, now if you were to deliver a product, and you would be aware of a concept of product liability. In case the product liability arises, then, and if the vendor raises a claim onto you, then be mindful of the fact that it's not just the sole proprietorship firm which will have to pay off, but in case the firm doesn't have it, then the personal assets of the owner will also be dragged into, will also have to be utilized to pay off to make good the claims and the losses that may have been suffered by the third party. So you need to be aware of that particular fact, which is not the case in case of a LLP or a private limited company. Now, incentive linked registration. Now, here, because we are here to discuss startups and MSMEs. These two registrations, I think, is a must, and one should consider taking these. In fact, of late, I've seen almost all startups taking this registration, and it's really beneficial. I'll take you through it one by one. One is the recognition by the DPIIT, which is the Department of Promotion of Industry and Internal Trade, and the other one is the MSME registration. Now, to be eligible for a DPIIT registration, the startup needs to be incorporated as a private limited company or a registered partnership firm or a LLP. The turnover needs to be less than 100 CR in any of the previous financial year. Now, also the fact that the entity to be considered as a recognized startup, it can only be up to 10 years from the date of its incorporation. Also, such startup should be working towards innovation, improvement, development of existing products. It should also have the potential to generate employment or create wealth. So there is a simple process by which you can actually apply for a DPIIT registration. To add on to this, because if you register yourself as a DPIIT recognized startup, the other thing is, you could actually raise money through a convertible note, and that money that you raise would not be considered as deposit. So one should keep that in mind as well. The benefits that is available if you register yourself as a DPIIT recognized startup is that there is a self-certification scheme. Like you're aware, there are a lot of labor laws which are applicable right from the start when an entity is in place. Now, because if you register yourself as a DPIIT recognized startup, the benefit that you get is there is a self-certification scheme under which there is one form that you have to fill up, and that could actually take care of your compliances in some multiple statutes or concerning labor laws. So that's a good benefit, because otherwise you would have had to actually go under each statute and make those compliances, while self-certification scheme takes care of one set of compliance which is applicable for a certain number of labor laws. There's an 80% rebate in filing patent applications and 50% rebate in filing of trademark applications. More often than not, I have noticed that startups tend to take this registration, but they are not mindful of the benefits that they get, that they can they can probably avail because of such registration. So 50% rebate in filing of the trademark application is the government fee that you pay. You get a 50% rebate on that. That's a big thing. That's it actually promotes the fact that you should probably take effort to register your brand, register your logo, register the brand name that you create or you will create for that particular business. Because what happens is, when the investors are coming in tomorrow, you don't really want to fall in trouble, and then when you make an application you realize, oh, there's somebody already in the market with a similar name, or they may just file objection when you make an application, and then to deal with that particular thing becomes a little tedious, and that also affects your valuation ultimately. Then there's a faster exit mechanism available under the IBC, which is the Insolvency Bankruptcy Code. Also, there are various funding support and tax exemptions available for a DPIIT recognized startup, which one should be aware of. Also, you as a startup, as a recognized startup, you can also avail the facilities under the Credit Guarantee Fund scheme. Next is the MSME registration. You may be aware that earlier, the MSME registration, there were two different criteria, which is as a manufacturing unit and a service sector. Now that has been done away with, and all you have is the criteria is based on the investment and the turnover. So in case your entity, your enterprise's investment is less than 1 crore, or the turnover is less than 5 crore, then you go under the micro. Then there's a small enterprise where if it's less than 100 crore, 10 crore of investment and less than 50 crore of turnover, then you are categorized as a small enterprise. And moving forward to the medium, in case your investment is less than 50 crore and turnover is less than 250 crore, then you are categorized as a medium enterprise. There are various benefits again that you get if you have an MSME registration. Very importantly, that I would like to point out is the one where you get protection under the delayed payment. So in case there is anybody who any vendor, any company which is a recipient of the goods and services of an MSME, and the payments are not made within 45 days, then there is a particular mechanism provided for under the act by which the payments are to be made along with the interest. So there is faster mechanism to deal with such matters. Also, there are facilities like lower rate of interest on loans. There is collateral free loans available to MSMEs. There are again IT exemptions available and subsidies on patent registrations. Also, there are reimbursements available in case the MSME enterprise goes in for an ISO certification. The charges are certainly reimbursed. Also, there's incubation schemes available and grievance monitoring system in place in case there are any kind of disputes. In fact, the MSME Act itself provides for a dispute resolution mechanism, by which any kind of dispute that may arise, the council can be approached for such matter. So moving on, so like I said, I will I will take you through the entire part about the basic things that a startup needs to keep in mind. So the first was the kind of entity that you need to have in place that you can consider, keeping in mind the objective in mind for the business. Second is the incentive linked registrations, which according to me, any startup in MSME should obtain, any entity should obtain, because there's a lot of benefits that you can avail. Moving on, the basic licenses and registrations to be obtained. One is the shops and establishment registration, which more often I've seen people tend to ignore, but there are penalties involved which one should be mindful of. Then is the GST, of course. If you're generating revenue, then a GST registration is a must, so that you can claim input tax credit. Then is the PAN-TAN registration, the professional tax. In case you're looking at importing or exporting, then the import-export code registration is a must. The employee-related benefits and registrations like the PF registration, the ESIC, all of that needs to be kept in mind. Any other business specific licenses also you need to obtain. So in case you're a pharma company, and in case you are into R&D or manufacturing of any drug, then the Drugs and Cosmetic Act applies. In case you are into probably manufacturing or producing tea, for instance, then the FSI and the Legal Metrology Act applies. So even once you've identified the business that you intend to do, you need to certainly look into the business specific licenses and the compliances that need to be in place, because tomorrow when you're looking at getting an investor on board, the investor, when they carry out a diligence on your company, these are the basic things that they would look out for. In fact, more often than not, what we've seen is that these licenses, if at all you don't have, the compliances are not in place, then there are hefty penalties which you don't really want to incur at that point in time, and it also affects your valuation. Then is the routine compliances. If you're looking at a company, setting up a private limited company, or a private or a LLP or a partnership firm, then the secretarial compliance is something that you need to keep in mind. You probably would have to have some sort of legal support, external legal support to take care of this, because you don't want to be missing out on the due date. Then is the tax related compliances, GST, and the IT related compliance is something which you need to be mindful of. Then, like I said, in case for example, under the DNC, the Drugs and Cosmetic Act, there are a couple of compliances to be done annually, quarterly, monthly. You need to at least have some sort of idea about what it is, and then you could probably approach the relevant consultant to take care of it. In fact, as an MSME or a startup, you could actually, once you've identified the compliances, etc., you could actually have a probably a tracker, a checklist in place, so that you may not be able to do it yourself, but at least you are aware this is what is to be done. I mean, these are the internal processes that you could probably have in place right from the beginning, so that tomorrow it doesn't become too heavy on you to take care of. Then is the labor law compliances. Where labor law compliances, there are there are quite a few labor legislations, unfortunately, which need to be complied with today. We are hoping that the labor codes, the four codes which have yet not been notified, but the bills are floating around. I hope that it gets notified soon, and it becomes easier for any enterprise to comply with those compliances under just those four codes. The four codes are technically to they consolidate various other labor laws together. For example, I'll tell you, the POSH, the Prevention of Sexual Harassment at Workplace. Obviously, that does not cover under labor law compliance, but the fact that if your strength of the office is more than 10, if you have more than 10 employees, be it women, men, the fact that you need to have an IC in place, you need to have a POSH policy in place, is something that you need to be aware of, right? So be mindful of the rules and regulations and the norms that are applicable right from the beginning. It's not just about doing business. So through our startup cell, what we notice is that the entrepreneurs, the founders, the promoters are very enthusiastic about the business that they want to operate, but they tend to ignore the law part of it. Unfortunately, ignorance of law is no excuse. So the penalties remain the same even if you avoid it, you evade it, or you actually don't have an idea about it. So it's better to have an idea so that you plan accordingly. Yes, these do involve cost, but like I said, if you intend to get in investments tomorrow, third party funds, then these are a must. Moving on to key contracts, while in at initial stage you tend to have some sort of oral contracts, etc., but that's not healthy for the business. Firstly, your business, your idea is proprietary to you, right? So to protect that, how do you do it? You do that by way of entering into an NDA every time that you are sharing your business ideas, the products of your business, with a third party, with a consultant, whoever it is, does not matter, but have an NDA in place, right? So that your confidential information, the IP around it, is duly protected. There is the NDA takes care of it, but ensure it's watertight. Then is employment letters, employment agreements, appointment letters. In case you intend to hire any employees on board, do execute appointment letters, that too the ones which are quite comprehensive, to take care of not just what you are going to be paying them and what they're required to do in case of basically not just job description, but also have provisions in place to say that in case they breach any provision, then what happens. Provide for a proper mechanism in place, so that in case there are any unfortunate incidents tomorrow with those employees, the contract takes care of it. Then are vendor contracts and service contracts. These again, in case you are into the service space, or in case of you're into the manufacturing space, be mindful of the fact that you need to execute these contracts and go through the specific terms in the particular contracts. Some of the very basic terms, like I tell my clients to keep in mind, is the confidential information. Be careful that your confidential information is duly protected under the contract. Also, your IP is protected. There is no infringement of IP that happens. Be clear in the document that whatever IP you share belongs to you, right? Thereafter, indemnification provisions. In case there's any infringement or any breach that happens from the vendor's side or the consultant side, be be clear in the contract that they are going to be indemnifying you. While you may be required to indemnify them for a particular things, please be mindful of the fact that your liability is duly limited to the amount that you receive or pay under that particular contract, because unlimited liabilities are not healthy for the business, and investors also don't really look at it in a good way. Thereafter, in case of appointment letters, do have non-compete, non-solicit provisions in place. That's very important, because you don't really want the employee to get into any similar kind of business. Then is IP ownership assignment agreements. In case you have hired any third-party consultants to develop an IP for you, please do execute assignment agreements. I'm not say these are basic contracts that you have to have in place, not just from an investor's perspective, but also to protect your business ideas, and so that your business has a longer lifespan, right? Then is ESOPs and sweat equity. As a startup in MSME, more often you are very tight on liquidity. So what you do is, there are these ESOP plans that are drawn up so that you can give more incentives to your employees. In case of a tech platform, do have terms and conditions and privacy policies in place. Please keep in mind that more often we've seen people copy pasting your terms and conditions from some other platform. uh, while it's okay to do that, but the thing is that it's not specific to your business, your the way your business operates. So just try and see to it that it is structured in a way that it is specific to your business, right? So these are the basic contracts that you should have in place. And also, please ensure that these contracts, whatever you execute, has a proper jurisdiction governing law provided for. Also, a dispute resolution provision provided for, because it's very important. In case there are any dispute differences that arise tomorrow, then there are mechanisms already provided for in the contract, which will take care of how one should proceed with such disputes, right? Moving on to protection of IP, like I said, it's your business, your idea, your brand, the goodwill that you create. Hence, it's very important for, in terms of valuation, in terms of getting in money tomorrow from investors, also for a longer lifespan of your business. It's important to register your IP, be it trademark, brand name, design, copyright, patents, whatever it is, do it. It does involve cost, but in the longer run, it is usually beneficial for your company. Then, of course, in case you are developing, if your entity is developing a particular product along with another consultant or another entity, and the intent, the commercial understanding is to jointly own that particular IP, please do enter into a co-ownership agreement, because that will take care of your right in that particular IP which has been jointly developed. I think that's all from my side. I will give the mantle to Nazneen to take it forward to discuss on the funding trends for startups. Thank you.
Thanks, Rohini. I'll just take a minute to share my screen and then we can start off.
Yeah, thank you, Rohini. Yeah, as while Nazneen is preparing, if there's any questions, please do put it on the Q&A section. Thank you.
So, very good evening to everyone. It's my pleasure to be here today and interact with all of you. I hope you could gain some valuable insights and useful tips from the earlier session conducted by my colleague Rohini. Moving forward, I would like to take you all to the other very important aspect for any startup business, that is the fundraising exercise. Now, in this regard, the very first thought that entrepreneurs need to keep in mind and evaluate as to what is it that distinguishes their business or the services and products that they are offering from those which are already positioned and available in the market. What is the unique selling proposition which will make your business attractive to the proposed investors and encourage them to invest in your particular business as opposed to any other products and services that are competing and available in the market? So identifying your startup's USP, identifying the market appeal that your product holds, doing a proper research in this regard, and making a good pitch to the proposed investor would go a long way in gaining prospective aspects for the startup to go ahead with the fundraising exercise. The next important stage for any startup entrepreneur is to evaluate at what stage the bootstrapping should end and when it should approach for an external funding. So there is no straitjacket formula that would universally apply for all startups. Each startup has specific dynamics of its own with respect to its business realities, its products and services that are being offered. And accordingly, each founder or each entrepreneur would have a different resource in terms of funding and other resources available to it to put it in its bootstrap business. So every person, every founder, when he's starting off, would have some budget in mind to that aspect. The important thing to keep in mind is that once you are close to reaching that budget of bootstrapping financing, you need to keep a buffer of at least 9 to 12 months and start your fundraising exercise a little bit in advance. Just to take into account, because sometimes, say earlier in 2020, when the pandemic suddenly hit us, there was a lot of chaos and there were disturbances in terms of various business transactions that were ongoing. So in case, because of certain unforeseen circumstances, maybe due to some natural calamity like what we've recently faced during the pandemic time, or it could even also be because of certain economic or other business related factors, it could happen that the process of fundraising, which should ideally take anywhere around 3 to 4 months or even up to 6 months, gets prolonged and goes into a time span of say even 9 to 12 months. So as a business, you need to ensure continuity and make sure that you are not starting the process of initiating the fundraising exercise, making your pitch to the investors, etc., at a very late stage when you are closer to exhausting your limit. So finding the right time or the right stage where you begin the fundraising exercise approach and start interacting with various investors, preparing your pitch and presenting the facts and your business plan, etc., to the investors. That entire process needs to be appropriately calculated and initiated well in time. The other important factor that startups and entrepreneurs need to keep in mind is to take stock of what are the current trends, what are the available sources of funding that are available for them, and identify what would be the best fit for them. So to give you a few examples of the more popular source of fundings, and these are practices again which are evolving. So something that may not have been popular 5 years earlier, like a peer-to-peer lending platform or a crowdfunding platform, are also available sources today, which you need to be aware of and decide what would be the best fit for your particular business. So to name a few sources, the angel investors or the seed investors are the more traditional source of funding for startup businesses. Then comes your venture capital equity funding and investors. I will go into these different sources of funding and trends in funding in more detail in the earlier slides. So right now, just to give you an example, I've quoted these. And of course, then there is the more traditional source of debt funding, which comes from banks and other financial institutions. The fourth important parameter to decide and keep in mind when you are going to make your pitch to the proposed investors is in return for the funding that you will raise from these investors, what is it that you are willing to give in return? So before you approach them, you need to have a clear idea and at most clarity in your mind in terms of these aspects. Is it an equity security like an equity share or compulsorily convertible preference shares or other convertible securities that you would like to offer in exchange for the funding? Or would you like to structure your particular business funding in terms of a debt? It's also possible to structure it through a hybrid model of both equity cum debt. So again, keeping in mind what would be most ideal or most suitable depending on your financial realities, the scope of your business, how much is the quantum of amount that you are looking at raising, keeping in mind all these factors, you need to take a call on what is it that you are going to be offering to the investor in return for the funding. Often the startups can take advice and guidance on these aspects from various external consultants and support groups that are available, various incubators and other networks who also guide entrepreneurs in these important aspects and help them make a decision in this regard. Significance of startup funding. So why is raising external funding important, or what is the value add that this funding, other than the obvious that it gives you the valuable working capital and growth capital that it gets into your firm? Other than that, are there any other advantages why you should consider and opt for going for external funding? Yes. So besides the working capital that it provides you and the funding that it provides you, which is very essential for scaling up any entrepreneur's business beyond a particular stage, there are a host of other advantages that an investor coming into your company would also get to offer you. And these are important aspects that you can also keep in mind while trying to determine what type of investor would be ideal or a best fit for your organization or your business. So some of these other value adds that an investor would bring into your company is his entire network. One of the most important ones is his entire network of resources, be it in terms of consultants, be it in terms of his connects with other players in the market, other investors, other contract partners, other vendors, etc., whom he may have a good hold with. So with his reference, there is an entire other world of contacts, networks, resources that is also opened up for you, which individually or independently, you may have taken much more time to connect with these people. And also, since there is a common factor or a known person who is referring you, these other partners would be taking you more seriously in terms of evaluating and partnering in your business. So the reputation also, that the fact that this particular investor has trusted his funds in your particular startup or business would go a long way in increasing the appeal and marketability of your business in terms of various aspects, not just fundraising, but also in terms of building your brand reputation and other business related aspects. Exposure to new ideas, exposure to others. So usually when angel investors or venture capital investors are investing in your company, it's not that they are investing only in your business. They already have an established network where they are parallelly working with various other startup businesses and co-founders. And by getting on board into this system along with the particular investor, you also to a great extent would get exposure to newer ideas, newer innovations, what are the trends that are ongoing in terms of different practice realities, or simply discussing, some situation like a pandemic. If say you are an IT business and to some extent you are looking at scaling up your business because the marketability of your business or services right now has gone up on account of a lot of people resorting to online means. You would like to get another perspective of what other founders similar in your situation are doing right now. Or if there is a crisis situation, if somebody has faced a similar difficulty as yours, it is always useful to learn from others' experiences and thoughts and exchange ideas as to how they are handling a particular situation, and make advantage of that knowledge and exposure for the benefit of your business. guidance, mentoring, and expert advice in the form of say, what are the market trends, what are the other trends relating to your business that you may not be aware of, could be an interesting perspective that the investor, having had an exposure to various startups across fields and across different regions, may also bring in that value add onto the table when he comes in along with the funds. So these are a lot of other nuances that are also important, which an investor, when he comes in with the funding, would get as a value add to your business. And it's not only limited to the economic benefits or the funding benefit that he would most obviously be getting in. So moving on to different types of trends or sources of funding that are popular right now, especially from a perspective of startups and mid-sized businesses. So one of the important sources is crowdfunding, where we are talking about raising capital with collective efforts from multiple individuals who have ideal resources available by way of the internet or online crowdfunding platforms. So to name a few popular examples, especially in India, we have crowdfunding websites like Milap, Keto, Kickstarter, who help startups register their business and avail funding from the investors who are registered on these crowdfunding websites. So often crowdfunding is a source of funding, especially in India, where the returns from the company to these investors is not more so in the form of equity of the company, but more popularly in the form of, say, donations or a debt like a term loan, which has to be returned after X number of months or X number of years, or it could often be in terms of rewards. Now, rewards could also be in terms of, say, any product or service that your business is offering. So in exchange of certain amount of money that an individual is giving you, he may expect, if you are in the business of providing, say, services in a particular line, he may expect a membership for a year, or he may expect a certain value of products that you are anyways offering in the market for his business at a particular value. So quite often through these crowdfunding platforms, individuals are willing to give funds, especially to startups, not just in exchange for an equity stake in your company, but in other more creative ways in terms of structuring it through goods, services, and quite often as in the form of support donation or initial contribution as well. The other advantage of having your business listed on these type of crowdfunding platforms is that it quite a lot increases the visibility or the marketing aspect of your business and services, and without there being any additional cost involved in this. So because of these reasons, of course, the quantum of funding that you can raise through these platforms is also typically in a lower range. So depending on the monetary requirement that you have, this could be a good source of initial stage or interim funding, just between, say, when you are close to exhausting your bootstrap limit, and while you are in the process of identifying and striking a deal with more serious investors like the angel investors or a venture capital investor. So this could be a good source of interim funding and also help build the branding and visibility of your products and services. With the stress and the focus on the Make in India initiative and the government's efforts to nurture startups, there are also various incubators and accelerators which provide support in various forms to startups and entrepreneurs. So accelerators help in advancing the growth of the existing startup companies in terms of supporting their idea innovation, in terms of providing them infrastructure, quite often also in the form of co-working spaces or office space at minimal or very low costs. There is mentorship and networking opportunities that they help in providing to these type of startup businesses and entrepreneurs. They help in conducting various sessions, help in resource management in terms of what are the popular trends in getting, say, HR related function or getting an online accounting related function, which could be pooled and shared through the accelerator network, where various small businesses and startups can avail the benefit of these resources. as opposed to when you are independently functioning and not as a part of these type of accelerators and incubators. Every small cost, say for engaging a financial consultant, or for getting an office premises independently of your own, or even the infrastructure such as electricity, getting an entire computer and internet facilities set up exclusively of your own, could involve a lot of time and resources, which gets saved and split to a great extent when you are a part of the accelerator and incubator network. Not to mention the financial support in the forms of various rewards and initial funding that they offer to the various startups and founders that are a part of their network. So some of the prime examples of startups who have flourished with the support of incubators and accelerators is Y Combinators is one of the leading examples that we have from the US, where they support various startups across the world, and Airbnb being one of the most famous examples of having incubation and acceleration support from Y Combinators. Even in our very own local turf, there are various IIT, IIM driven cells which offer incubation and acceleration support to the startups in India. Even the tech giants, even the global companies and MNCs are also seeing advantage of facilitating various accelerators and incubators. They have also started offering support, like corporates like Tata's, Mahindra and all are also offering these type of support programs where they get to interact and support the startups at an early stage. So it would be advisable, depending on what your business requirements are, to choose which accelerator or incubator fits well for you in terms of your business growth, and take support from these networks and make the most of them. Another popular form of sourcing of funds for startups and entrepreneurs in today's time especially is the peer-to-peer lending platforms. So these are facilitators which help connect startups and businesses who are in requirement of funding with other individuals. It could quite often also be in the forms of friends, family, and also in the form of other completely non-related individuals who have funds to spare and are looking at making an investment in a particular idea or a particular product. So these type of peer-to-peer lending platforms help connect various individuals with different types of ideas, businesses, and startups that they can consider investing in. It is quite a popular trend in today's times in India, and some of the examples of popular peer-to-peer lending platforms in India being Invoice Bazaar, I2I Funding, Lendbox, where you can register your business, put up your funding requirements and the mode of funding that you are looking at, and connect with these individuals who have excess funding. Quite often there are also NBFCs who are registered on these peer-to-peer lending platforms, and they follow the advantage of going for funding through a peer-to-peer lending platform is that the time and the formalities and the process that you would otherwise have to go through in order to raise a similar type of financial facility from, say, a bank or a proper financial institution would be much more tedious and comprehensive. So this is a more, say, a shortcut way of sorts in order to connect with people who have surplus funding and remove the middlemen from being in the picture, and directly connect the people who are in requirement of the funds with individuals who have surplus funds to lend. So this initiative can also be evaluated when startups are looking at raising funding for their businesses. Coming to the more conventional methods of startup funding, loans from banks and financial institutions is of course one of the popular ones. But then depending on the type of business or product or service that you have, it is very difficult for all types of businesses, especially in the startup stage, such as various say e-commerce related startups or IT related startups, where the value is in terms of their business plan and service that will come in at a future date if you are following a SaaS model for offering various IT services, etc. These type of businesses are not very ideally suited for banks and financial institutions to venture into and give loans to you at a very initial or nascent stage. So because of which to bridge this gap in terms of funding requirements for the startups and coming up with more creative ideas for startup funding is how the other sources that we saw, recent trends in terms of crowdfunding, peer-to-peer platforms, etc., came into the picture. The other popular forms of startup funding are, of course, angel investors. These could often be high net worth individuals, or quite popularly group of individuals who come in together, identify a good idea or a good business to pool in their money and make an investment into the startup company, as well as venture capital investors who pool in funds from various resources and make an investment not in their individual capacity, but through a more organized form, say like a separate alternative investment fund or a separate fund that they have registered, and make available the pooled in funds in the form of this particular organization or fund that they have formed, and make this capital available for startup investments. So to give one of the popular examples for other angel investors, we have angel networks in India like India Angel Network, the Mumbai Angels, VCAT investors, who connect such type of individual angel investors who can pool in the funds and create a larger quantum of money that they can make available to a particularly lucrative idea or business offering for startups. Another popular example of angel investments, if you are aware of this reality entertainment show that we have, which is Shark Tank, where various startups come up with their business idea and make a pitch to the investors and get funding from the angel investors who are a part of that reality show. So these type of methods of funding are popular for startup funding, not just in other jurisdictions like US, Europe, and also catching up in India to a great extent. Venture capital fund investors are more systematic and more organized in terms of their approach in startup funding. And the other aspect to keep in mind in dealing with them, that often because they are a fund and they need to protect and are answerable to in turn the contributors of their fund, the documentation and negotiation process in terms of the investor rights, etc., would be a more formal and a more not per se tedious, but it would be a more comprehensive process when a startup is raising funds from a venture capital fund or a organized institutional investor, as opposed to individual investors who are the angel investors, because they are dealing with their own funds and are at the end of the day responsible for their own investment decisions, whereas venture capital funds are pooling in money from various contributors, and then they are answerable to these contributors also in terms of what are the investment decisions that they are taking. So the process that they need to follow in terms of managing these funds from the contributors needs to be more comprehensively documented at the time of investments. Before we come to various aspects of investor related documentation and what are the typical rights, etc., which are very important to keep in mind when you are negotiating an investment document or investor rights with various types of investors. Another recent trend that in our experience we have been coming across recently is that more and more startups are going for another popular form of investment through ISAF notes. So India Simple Safe Agreement is nothing but a briefer version of your typical investor document, which is more suited for early stage or startup funding and more favorable from a company and entrepreneur's point of view in terms of getting a check from the investor without getting into a lengthy negotiation process, because the rights that you offer and the standard documentation is already available. in a standard form, and most investors who are looking at investing through an ISAFE are already aware of this. So the time in preparing the documentation, completing the legal formalities, and even in terms of the valuation exercise. So the unique feature of these ISAFE notes is that you get a check from the investor at a very early stage when your business is just kicking off. And we've come across companies who have got ISAFE investments, say, even within a month or a month and a half of having started their business activities. So here you get an early ticket check without having to go into a detailed valuation of your business, services, etc. And the idea being that when the next main round of funding happens, at that time, the detailed investor documentation and evaluation of the round at which the ISAFE notes would convert would occur at that future funding round and not immediately. So originally, this concept or this instrument was introduced in the US through the Y Combinator's fund, and 100x VC fund has got this concept to India. They have customized it and in terms of Indian laws, and often these ISAFE agreements are backed by instruments which are allowed under companies law in India in terms of convertible notes for startups that Rohini mentioned earlier during her presentation, as well as compulsorily convertible preference shares, or even compulsorily convertible debentures if you are looking at an aspect of debt investment also into your company. So often these ISAFE notes or ISAFE agreements are backed by these form of securities which are issued under company's law, and with a simple document which is, say somewhere in between what you would have a detailed term sheet and just brief rights that would otherwise typically go into a detailed investment document. Somewhere in between, you have a 5 to 6 page document that you can close off on with the investor and get an early check into the company. So with that, we'll come to the various terms and conditions, investor rights that you need to familiarize it before you start any type of dialogue with prospective investors, just so that you are aware of what you are negotiating, what are the types of rights that you would like to reserve completely for yourself, whereas what are the type of provisions that typically investors across various sectors or while making investment in these type of businesses are getting into, and what are the customary trends in terms of what is considered as acceptable. So firstly, coming to one of the basic ask that any investor, an angel, be it an angel investor or a VC investment fund, is looking at while putting in the money into the company is the lock-in period for the founders' shares. Now, they are trusting the money into the company on the basis of the founders who are going to be driving and supporting the venture. So the first ask or the minimum ask from the investor end is that while their investment money is locked in into the company, similarly, the founder shares should also be locked in during the time of their investment. Now, here, one of the important aspects to keep in mind that while a lock-in period is very normal to have, what are the parameters from a company and founder's point of view that you can negotiate with the investor? So to give you a recent example, for one of the startup companies in the IT space that we were recently working in, when the investment document came from the investor's end, from their legal counsel, the lock-in restrictions also included not just till the time the investor is holding shares of the company, but even for a period of 3 years after the termination of the document. Now, these type of restrictions, it is very important for the founders to know that, there is a room to negotiate these type of provisions. And what is a reasonably accepted norm is that your lock-in should extend only till the time the investors are holding shares in the company. Because once your investor has exited the company, what you do with your shares is entirely up to you and up to your rights. But in this case, if the founders were not aware of this and they were just looking at signing on the dotted line based on what document the investor has sent them without really going into the fine print, they would lose out on valuable conditions, valuable terms and provisions that otherwise are important in the long run for them to keep in mind and negotiate at the time of the fundraising exercise. Another leeway when you are dealing with lock-in provisions is that there is a room of say a small threshold of 2 to 5%, which you can have unvested or lying with the founders without a lock-in without a lock-in restriction at the end of every year during which the investment tenure is in place. So say at the end of completion of 1 year from the investment date, say 0.5 or up to 1% of the shares that the founders hold are removed from the lock-in restriction and would vest with them to deal with freely as possible. This is the logic or the rationale behind why the investors allowed this room to founders is, in case of dealing with certain emergency related liquidity provisions. This is a nominal amount that the founders or the holders of these securities may want to pledge or otherwise create liquidity against, or transfer to somebody in their friends and family and liquidate and get funding from them. So these type of small things that you need to keep in mind when you are negotiating these type of investor rights, that while the lock-in period is important from an investor perspective, there are certain trends and leeways that you have a room to negotiate and get in your favor, so that your future course of business is a little more flexible and your interests to an extent are also protected as founders of the company. Another important provision that any type of investor making an investment in your company would typically ask for is the anti-dilution provision, where the typical ask is that when a next round of funding happens at a similar valuation or a lesser valuation, then the type of rights that you are going to be presenting to the investors will not affect your stake in the company. So you will have the right to maintain your percentage at a particular threshold that was promised to you, and your shareholding will not dilute beyond a particular percentage. So this is one of the common asks that any investor would expect while making an investment into your company. Board rights and board observer rights, appointing a director on the board of your company, appointing a board observer to witness the process whenever you are conducting board meetings and what type of decisions are taken, having certain veto or consent matter rights where the company cannot go ahead with a decision on certain mutually agreed points without getting the consent from the investor, are typically what is laid down in an investment document when the investor is looking for board and management related decisions of the company. Then another important aspect, especially from the point of view of the founders in the company, is the representations and warranties that are being made to the investor. So these are nothing but factual statements regarding the business reality of your company, the status of your company, the status of the licenses, shareholding, various other compliances that you have entered into in the normal course of business before the investor is putting in the money into the company. So during the due diligence process that any investor will conduct of your company and evaluate various information and financial statements, documents, licenses, status of the compliances, whether any litigations have been initiated by your company against somebody, what is the nature, whether you have received a legal notice from any regulatory authority or from any other third party. So all these are typical aspects which are covered in a due diligence process, and these are also reflected in the representations and warranties that every founder and company needs to make to the investor with regards to the business realities pertaining to the period since the incorporation of the company when it started its business up to the date on which the investment funds come into the company. Now, this is linked with another important aspect, that is indemnification rights of the investor. So typically, if any claims were to arise for any, say, non-compliance or a breach that happened in, say, sometimes not even intentionally, or you may not have cognizance of it, but involuntarily, that because we have a host of legal compliances to be maintained, which, say, you were not aware of, and because of which the non-compliance, there is a penalty being imposed on the company. Now, the investor's logic is that the investment fund that he's giving or extending to the startup business is not to be ideally utilized for making covering these type of losses or penalties which are pertaining to the period prior to the date in which his investment came into the company and which were otherwise responsibility of the founders and the company in the earlier period. So which is why what every typically investor would do is take an indemnification from the founders that if any such claims, penalties, losses were to arise on account of the business that you have been conducting prior to the date that the investor came into the picture, it is the business of the company and the founders, and they will have to make good these losses or claims without resorting to the investor funds. Or tomorrow, if any penalty or something is imposed against the investor himself because of his association with the company, then it is the company and the founders who would be responsible for bearing that loss or penalty amount or claim amount that has been made against the investor. So again, while these are very common pointers for any investor to expect from a company and founder where he's making an investment, there are certain things that the company and founder can keep in mind and have a leeway in negotiations. So one of the popular rights that we negotiate and get for most of the company and founders where we are representing is the limitation of the liability in these type of indemnification events to the extent of the investment amount that has been made into the company. So instead of having an open-ended liability on the company and founders, there is some quantum or some benchmark which is usually pegged in terms of the investment amount that each particular investor has got into the company, so that the company and the founders also know that what is the quantum of that liability, and it is not capped at an open-ended amount. It is capped and not kept at an open-ended amount. So unless the founder is aware that these type of rights are being negotiated by founders and even being allowed by investors, he would not know what are the rights that he needs to ask for himself while negotiating a healthy investment document, which is balanced, of course, while ensuring all the protection to the investor, but which is also balanced and to a certain extent fair to company and the founders also. Exit rights is another important aspect that every investor will look into in terms of securing his exit, say 3 years down the line, 5 years down the line, or 3 to 6 years is the common range that we have come across, where investors investing in startups have typically made an investment commitment for this period. And various forms of exit rights, like, the company and the founders agreeing to do a buyback of the investor shares at the end of this investment tenure, or arranging the company and the founders arranging for a third party buyer who is interested in buying these securities from the current investor. So these type of exit rights are popularly negotiated and agreed in the investment document as to how the exit of the investor would be secured. So while investor expects a guaranteed rate of returns in the form of IRR at the time of making an exit on the investment, that is something which we have seen more often in the case of mature investors, mature investments, or mid-size companies going in for a later stage funding. In case of startup funding, it is quite common to just give a guarantee from the founder and company's point of view that the investor will get back his entire investment amount along with the accrued dividend rights that he has, but not guarantee a specific high rate or coupon rate of IRR in the document while you are making a commitment of the exit rights to the investor. So this is something that company and founders can keep in mind while negotiating the documents with the investor. Coming to the non-compete restrictions, which is of course another very common ask from any investor making an investment into startup business, is to ensure that founders and certain key employees that are identified by the investors are during the tenure of the investment, while the investor is holding the securities of the company, they cannot go and join or start any competitive business which is similar to the business of this company where they have invested the funds, either directly in their own name or indirectly through tying up with somebody else, or make an investment in the name of their wife or other relatives or family members and start another competing activity. So that is another important restriction that any investor would expect from the founders of the company and certain key employees of the company. Of course, the detailed document would cover much more detailed rights in terms of various aspects like shareholder meetings, quorum rights for conducting the meeting, and just wrap up with another last one being the governing law, jurisdiction, and dispute resolution rights that you need to keep in mind while negotiating the document. So what we usually do is, since the court process in case of any dispute that may typically arise between the company founders investor relating to the investment documents, the faster and the more cost effective method of dispute resolution, which is firstly trying to resolve the dispute amicably through mediation, and if that does not work, then having an arbitration clause in your agreement to resolve the dispute. And only then, if required in certain cases, as provided under the Arbitration Act, the parties are free to go and approach the normal courts of law in case of any relief that they are seeking. So to have a healthy dispute resolution mechanism, keeping in mind that tomorrow when the need for when if the dispute arises and the need to invoke this clause happens, it should not be just that it is a paper clause that you have entered into without thinking. So some of the things you can keep in mind is that, when you have a panel of 3 arbitrators or more than that, the cost of your arbitration will increase that much. Whereas if you have a sole or arbitrator, the control that you have in terms of the cost of the arbitration is reduced to a certain extent. So while any standard boilerplate document that is coming from the investor side may contain a fancy clause which having a panel of 3 arbitrators, etc., it would be prudent for you to request that, we have the appointment of a sole arbitrator instead of an arbitration panel to try and have a control over the cost of the arbitration proceedings. Another popular thing to, typical thing to keep in mind is that when you have the venue of arbitration and the seat of arbitration mentioned in the document, you can typically agree on something which is neutral, and the choice of rules that you will follow for the arbitration is also something that you can give a thought and spell out in the document, so that in case tomorrow, if you need to invoke this clause, these provisions do not come and bite you at that point in time. So these are some of the important pointers that, every entrepreneur and company, before going ahead with the fundraising exercise, needs to educate himself on, and not just focus on the business and business products and activities of the company, which is of course very important, but these type of rights and educating yourself as to these type of trends and rights is also equally important for having a healthy relationship with your proposed investor who's making the investment into the company, and ensuring that the document that you are ending up with at the end of the day with the investor is healthy and balanced to a great extent, and does not, and also permits certain amount of flexibility to you in conducting the business. With that, I'll wind up our session for today. We can have the question answer session. This is just the last slide where some of the unicorns that we have come across recently: Dream 11 Fantasy, who managed to get funding from Kalari Capital, Teneset, Multiples P, and various other funds. Urban Company was another unicorn which picked up funding recently. Cred, which is the credit card payments platform that is recently in the media for its new set of advertisements that it has come up with. So they also managed to pick up the stake recently at a valuation of $2.2 billion from Tiger Global and various other investors. So with that, I would like to also wish all the very best to all the entrepreneurs in their startup journey. And if you have any questions or any clarifications on any aspects, then Rohini and I will be happy to answer them.
Thank you, Nazneen, and thank you, Rohini. I think it has been a wonderful session. Yeah, very insightful. Yeah, ignorance of the law is not an excuse anymore. I think you have covered the basic aspects of it, and more than the basics. Yeah, I have gone into a lot of depth in terms of each of the topics. Thank you. Yeah, we have some questions from the team as well. Yeah, so we have. I think the first question that has come was in the chat itself, in terms of. It is from Kurish. What is the registration fee for registering under DPIIT? You are muted, Rohini. I think you're speaking, but you're muted. Yeah, go ahead.
So it's a very simple process to apply for the DPIIT registration. Unfortunately, the government is not charging any fee as of now till I know.
Okay. So thank you for that. Yeah. How to identify the correct source of funding? This is a question from Mr. Balan.
Right. So unfortunately, there is no straitjacket formula for that. One is that you be aware of what are the latest trends and what are the options available to you. And the next best thing is that you need to evaluate these in terms of what is going to be most suitable for your business point of view. And another thing to keep in mind that you may not be able to take this decision on your own. So seek the advice of consultants and experts in this field. Say if you are part of networks where people are offering mentoring and other guidance, then take their help in being able to determine this question instead of trying to figure it out on your own. Other than that, it will vary from each business point of view as to what would be good source and what would work best as a fit for that particular business.
Sure, sure. Thank you. Yeah. There's a question from Viju. What is the most common form of funding in startups? How would you see Kerala startup companies conducive for funding? Is it generally in the tech space? So I think this is more from your experience.
Yes. So both Rohini and I recently have been coming across deals which are more so, especially in the last 1 year in the tech space and e-commerce space. And they have been getting funding from various angel investors as well as VC funds in the form of both iSafe notes as well as your normal shareholder agreements, investment documents. So this is what we have popularly been seeing as a trend in the last 12 to 15 months, even after the pandemic started in 2020. Of course, Rohini can add to it.
No, I think you covered it.
Yeah.
Okay, okay. So I think the next question was from Harseem. Yeah.
Yes.
So I represent an electric mobility sector startup seeking incubation and seed funding. There are exemption certificates provided for low speed electric vehicles that are plying on the road today. Although many two-wheeler companies do not abide by the speed and power ratings, in the startup's point of view, such laws help in test market entry of vehicles. How, but how should a startup focus on such legal and enforcement clauses?
Okay.
Uh, yeah.
I think
It's
Harshman will
more
have to be a
focused
little more
on
clear.
the electrical. Yeah.
Yeah, one is to be aware of what are the laws that would apply to you. And secondly, if you need any help in evaluating or understanding them, especially because they are very relevant or important from your business perspective, I mean, reach out to consultants to I mean, even if it involves a small amount of cost attached to it, I would say that it's a cost in time. It's not really a cost; it's an investment that you are making, which will help in saving future cost at a later date. So take that time and cost investment today, and identify these laws and understand them, and make advantage of it to the best of your business.
Yeah, please remember non-compliance can be more expensive than actually paying up for the compliances that you have to do on the first day.
Correct. Not just that, it also quite often, like we have seen in a couple of cases, it delays the entire fundraising process. Yeah, because see, if you have identified the non-compliances yourself by engaging a consultant and taken care of it in time, one, the penalty that you need to pay is going to be much lower, and secondly, if you wait for the investor to come in with his team of experts, do a due diligence, then identify these same non-compliances, he's anyways going to expect you to comply with them before he puts in his funds in the company. So at that time, the delay that you will have to bear and wait in addressing these issues and then get the funding into place, quite often the investor then just loses interest, because at the end of the day, they also have their targets to be met and all. So that decision can turn out to be much more expensive in the longer run.
And unfortunately, that also affects your valuation. So
Correct.
then they'll come back and negotiate your valuation. So then that's not good for your company.
Yeah. Okay. Thank you. I hope that answered. Yeah. Your question. So thank you. The next question is from Tanas. If I desire to raise funds through Keto or Milap, etc., is it okay to take these funds or donations directly into my company's bank account, private limited? What will this be termed as a deposit? do I have to comply with section 73 and the applicable rules?
From what I understand, you are supposed to give your company's bank account details and receive the funds directly into your company's account. Whether they will, whether the deposit rules will apply to these type of funding again would, I think, depend on what is the nature of what is the nature according to which you are structuring, these type of fund receipts, whether you are calling it a donation or are you calling it in the form of a returnable loan, or are you going to be accounting it towards giving some free products or services from your business towards this funding money.
So you're
So
saying
depending
that
on that, the treatment of whether the deposit rules will apply or not would vary.
okay, so as I understand, Nasreen, it's more of an accounting treatment rather than it should hit the bank account anyways. Yeah.
Correct. It should be in the bank account anyways. That's right.
Okay. Fine. Okay. I hope that was answered, Tanas. So Aditya is asking, what is the difference between peer-to-peer lending and crowdfunding?
Right. So peer-to-peer lending platforms are of different types, where there are individuals as well as non-banking financial institutions, etc., which tie up with various platforms. And once you have made a pitch for your particular business on that platform, they help you connect through various forms. Like, say, if you keep raising invoices for the goods and services that are provided by you, some of them are structured in the form of an invoice discounting facility that can be availed from the identified lenders on these peer-to-peer lending platforms. So it helps you directly connect with a particular individual and get the financing directly from that particular individual. Crowdfunding platforms like Keto and all are more in the form of you make known your requirement. What is the purpose of that requirement, like whether it is for a social cause or for some other business related cause, and then anybody who's browsing through the website is free to contribute towards that particular project that you have opened up. So it helps more in the form of pooling of various individuals who can invest in a particular project, and that target requirement of the startup is going to be met out of that requirement through various people who have pooled in the money into that project. Whereas peer-to-peer lending platforms just help you connect with each individual investor or lender on the platform, and you directly get into a one-on-one agreement with them, and they would forward the funds to you, depending on how the structure is.
Thank you. There was another follow-up question from Aditya himself. Is there any reliable source, open source documentation where we can have access to all informations related to law and funding for startup?
Open source documentation where you have access to law and funding specifically from startups.
Yes.
So various blogs and there are sessions conducted like the one we are having today, where you come across various experts who come and educate you on what are the various applicable laws. And there is a lot of literature in the form of YouTube videos and other social media where awareness is created on these topics. But there is no one particular codified law as such which would or a handbook that would apply to you. I mean, but yes, lot of legal professionals and even financial professionals come across write in various literature and various social media where they put across and enlighten you on various provisions that may be applicable from a perspective of startup funds. So you can read them in the public source. Yes.
Yeah, you could probably refer to them. However, you would require specific experts to really guide you through the process. Because
this is more in the way of educating yourself. Yes.
Yes, I agree. And I believe there are a lot of YouTube videos and things happening where people are also posting a lot of information on these topics as well.
Yes. What we've also come across is there are accelerators and incubators who do an empanelment with different professionals, and they make available appointment with these experts on a need basis at a very subsidized or nominal cost. So you can inquire within various networks as to if they have a empanelment process with various professionals and how to take advantage of those. So they can help you connect with them as well.
Okay, okay. There's a question from Suresh Manan. I think Nirmal would like to answer this. Is there any body or network of angel investors or venture capitalists? Nirmal, you there? Yes.
Yeah, absolutely. So TIE has a angel network as part of our activities that we do. We are a not-for-profit organization, but we have a branch out of TIE called the Kerala Angel Network. This was launched in 2019. It's already done 2 deals, and it's pretty active in this network. But other than the Kerala Angel Network, there is another one called Malabar Angels, just within Kerala. Outside Kerala, there are a lot many angel networks. Indian Angel is around
Yes.
Mumbai, Chennai
Yes.
Angels.
Yes.
There are many private angel networks too.
Correct.
Please reach out to the TIE office. We'll give you connects to some of these networks.
Thank you, Nirmal. I think Suresh, yeah, you could reach out to Nirmal and or the TIE office. Yeah. The next question is from Tanaz again. Which will be the most preferred instrument for fundraising, equity or CCPS, from investors as well as from the company's point of view?
From an investor point of view, I mean, they would of course always want to go in for a compulsorily convertible preference share as compared to a normal equity share, because it entitles them to certain superior preferences and rights under law. Whereas, so quite often the company and the founders may not have much of a say in that, but obviously from a company and founders point of view, if they can get away with directly giving an equity share to the investors, then that would of course be more beneficial for them. So that the type of security and attached rights, there is no superiority other than the contractual terms that you have promised given to them under law. The security is on a even footing.
So am I right to say that I think it's basically how it is being pitched to the investors, that they have to decide what is the kind of equity or the CCPS that they're going to offer rather than keeping it in open? Yeah, yeah.
Yes, yes.
Okay. So I think it's basically creating that understanding and having the correct messaging given to the investors at that point of time, when they're doing the initial pitch. Yeah.
Right.
Okay. So this was answered. Yeah. Okay. Then the next one is from Santosh. What are the inputs or factors for valuation typically? This is more on a valuation aspect.
Correct. Whether the method that is being used is based on your future projections of your business revenues or linked to your past financials, depends on what stage you're doing the valuation at. So whether there is an IP base that needs to be valued while determining the valuation of your business. So those type of factors would be considered.
Okay. Okay.
Sorry, Rohini, you were saying something. I didn't hear you. Yeah.
Fine. So there are more factors, and I think it has to come with a discussion when they're doing the pitch deck in terms of having a financial consultant on board and ensuring that they are discussing how they look at the future of the company. So that is how the valuation report should be written.
Because the first thing that any investor, while considering your pitch, will look into, one of the main things is your future projections. Where do you yourself value and see yourself growing in terms of the projections? So that will be one of the main things that they'll have to consider while working out the investment into your company.
So thank you. Yeah, thank you. I hope that was answered, Santosh. Next is from Mr. Arun. When an OPC exceeds rupees 2 crore in revenue or 50 lakhs rupees in paid up capital, you mentioned it has to be converted to a company. Again, which type of company is this? I think this is more on for Rohini. Yeah.
You got to convert into a private limited company. But let me tell you that when you actually make an application to convert from an OPC to a private limited company, it's a very long process. In fact, on the contrary, if you had to actually incorporate a private limited company directly, that will take you lesser time. So one should keep that in mind if you are intending to set up an OPC today.
Okay. Thank you, Rohini. Yeah. The next one is from Murshid. How to prepare an NDA?
How to prepare an NDA? Okay. There are a few things to keep in mind when you are drawing up an NDA. One is that, are you a disclosing party? Are you a receiving party? Are you the one disclosing the confidential information? Or are you the recipient? Two, what is the nature of business that we're talking about here? Three, the confidential information. What's the nature of the confidential information? Are we looking at patents? Are we looking at know-how? Are we looking at machinery, some technology? Be very clear. If you are the disclosing party, then ensure that you're keeping the confidential information definition quite exhaustive. Don't restrict it. Fourth, I'm sorry, the fact that to whom can the recipient, if you are the disclosing party, to whom can the recipient disclose the information to? Their affiliates, their employees, that too on a need to know basis. And the fact that they will have a back-to-back arrangement with those parties to whom they are going to be disclosing, that obligation needs to be imposed on the recipient. Fifth, the fact that there has to be proper dispute resolution mechanism in place. The fact that in case there's a breach, there's indemnification provided for. Your definition of confidential information needs to also take care of the IP around the CI. And last but not the least, the fact that for how long is going to be the term of the NDA, and the fact that it's going to survive beyond the term of the NDA. So these are the basic things to be kept in mind, but there is no one way of having an NDA. It's not like there's a one format. There are different formats, so it depends what you're looking at. You should probably consider having a consultant on board who could draw it up for you, considering the nature of the business and the CI that you have.
Okay, thank you. The next one was from someone who's anonymous. What is the best way to account investment from friends and families?
Give them a minor equity stake in the company without promising any additional rights other than what are normally under law associated with equity shareholders, and not give a series of other contractual rights that you would normally give other outside serious investors.
Okay. Rohini, you want to add something onto that?
No, it's okay.
It's okay. Okay. So next was a question from SK. Once the valuation is done, what is the most preferred mode of investment nowadays? The investors take it through a CPS or the old form of share premium with normal face value of shares.
Correct. That is the most popular mode that we have come across after the valuation is done, and if you are entering into an investment document. So face value plus a certain amount of premium depending on your valuation that is agreed between the investor and the company.
Yes, and as I think it was covered by Rohini, yeah, as a startup, I believe that even if you're giving it on a premium, the tax benefit is there, yeah, for startups that they don't.
Correct.
Have
if you are a registered startup, yes.
Yes, okay, so that is good. So the next one was from Shailaja. How many different formats can be formulated? What are the basic formats available for each? This is, I think, I'm not sure in terms of what is that you're speaking about, Shajila. Is this about different kinds of investments or valuations? I don't know what is that you're talking about. Can you just elaborate on this? And I'll come back to you. Yeah, if you're still there. The next one is from Balan. If we get crowdfunding, is there any tax implication? Is there a tax implication for crowdfunding?
I mean, the treatment will depend on what you are accounting the funding towards. Like I said, if you are a registered startup, then when you are receiving these type of fundings, there are certain exemptions that may be available to you. Or if you are accounting it towards premium over and above the face value, there may be certain tax implications that you may need to keep in mind. If you are accounting it towards certain goods and services that are being offered in exchange, or rewards that are being offered in exchange for it, then you can account it towards your normal marketing and advertising expenditure also. I mean, depends on the type of treatment that you give it.
Okay. Thank you. The next one was from Arun. Do you differentiate between firms and companies? That is proprietorship, partnership, OPC, and LLP will be firms. Private limited and public limited will be companies.
No, one-person company is also a company. It's not a firm, because the sole proprietorship is not really governed, but a OPC is governed by the company side. So that's also a company. Partnership firm and sole proprietary firm, yes, they are firms. They're called firms.
Yes. Okay. Nirmal, you want to add on to it?
Just about to alert you, we have overshot time, so probably we'll take one more question. If you have any further questions, participant can email it to us, to the TIE secretary. We'll take it up with Rohini as well as Nasri.
Sure.
If you can just take one more question and probably close.
Yeah. Okay. I think that was the last question. I'm looking at, Suresh was saying, thanks, very good. Thank you, Suresh. Yeah. We will share the recording later or upload it on our YouTube channel. Yeah, that is what I think you have said, Nirmal. So yeah, thank you. So I think that is it from the participants. Yeah, in terms of questions. Thank you, Rohini and Nazneen, for your time.
Thanks, Amit. Thanks, Nirmal. Thank you very much for having this.
Thank you, Rohini.
Having us
Thank you,
over here
Nazneen.
today.
Thank you. We'll probably have another round of interaction next month when we plan to have one more series talking about some of the compliances as well as licenses that companies would require. Thank you again for your time. Thank you for the patience. I think we have answered many questions. Like I said, if you have any more questions, please post it to the secretariat. We'll take it up with Rohini and Steve. Thanks everyone for joining. It's pretty late in the evening. We have a pretty exciting week coming up. In fact, TIE is doing a charity event this weekend. I'm just going to send a mail to all of you. Kindly do attend it. We've got a lot many celebrities attending this event. It's a charity event. It's primarily on YouTube as well as Facebook Live. And kindly donate to the cause of the COVID relief, which TIE and Give India is initiating. Thanks again for joining and have a great day. Thank you.
Thank you. Thank you for having us on board. Bye-bye.
Thank you.
Thank you.
Thanks. Bye-bye. Stay safe, everyone.